Hello guys, in today's video I am going to talk about section 22, 22A, 24, 28 and 29 of Indian Evidence Act. In the last video of Indian Evidence Act I have made it on admission and confession, in which I have dealt with section 17 to section 31, but these are some of the sections that I haven't talked about in the last video. If you haven't viewed that video, I will put the link in the description. First of all, you have to see that video, then only you will come to understand this section. Although these sections are not tough, they are easy and they are not so important as well, but in this series I will deal with every section one by one, so let's get started. When we talk about section 22 and 22A, basically section 22 and 22A are similar in nature, as both are talking about the oral admission of the content, but section 22 is talk about the document and section 22A is talking about electronic record. So both are saying that oral admission of the content of the document cannot be proved. Section 22 is saying that the oral admission of the content of the document cannot be proved unless the party is entitled to give secondary evidence. There are two types of evidence, primary and secondary evidence. 62 talks about primary and section 63 talks about secondary evidence. I will deal with this section in this series, but at this time you have to just understand that secondary evidence is not the original one, it is just a certified copy of the original one. Section 22A talking about irrelevancy of oral admission of the content of electronic record. Section 24 dealing with the confession. Section 24 just states as if there is any person, the accused, who is confessing his offense in a criminal proceeding, and if he is influenced by some inducement or any threat or any promise, then his confession will not be relevant. The court have to check that if there is any advantage to the accused person on confessing the offense, or he is just avoiding any evil of temporary nature. So section 28 just talks about that once the inducement, threat and promise removed, then the accused is free to give confession. So section 29 talking about that if a person is giving a confession, it will not be irrelevant if a person who is giving the confession, a promise has been made to him to make the confession a secret one, there is any deception that has been practiced on him, if the person who is giving confession is drunk, if the person is not bound to give an answer to the question but he did it, even though if he hadn't warned by the person that he is not allowed to give confession. These are some of the points. If a person giving a confession, it will be relevant even though if there is the presence of any of these 5 conditions. So that's all for today's video. Do hit the like button if you like this video. Do not forget to share and subscribe. Be connected for related video. Next video will be on dying declaration, and I will meet you in another video. Till then, goodbye.